Lawyers, has there ever been a time the opposing counsel accidentally proved your case for you? What happened? I had a hearing where the opposing party offered an updated contract that my client supposedly signed, except it was a horrible copy and barely readable. Then he assured the judge that the new contract was exactly the same as the old one, except for the party name at the top. The original contract was in his mom's name, the new one in his, as well as the date of the contract itself, of course. He made that assurance multiple times. After he exhausted himself saying how everything was the same, I then pointed out to the judge that half the provisions were different, and that my client had never signed that form. The judge asked if we were really accusing him of forging my client's signature, since that's a serious accusation. I held up the guy's prior conviction for contract fraud and said, "I absolutely am, Your Honor." We won, hands down. No further argument needed. Next story. My dad's ex-girlfriend took us to court over his estate after he kicked her out. Her claim was that she was entitled to half the pie due to de facto marriage. Our claim was that she was a gold-digging harlot who planned it from the beginning. She had mountains of evidence of her contribution to Dad's company and running the private estate. Expense reports, receipts, dates, and times her and Dad proved their relationship with trips and combined spending, etc. She had so much evidence, the judge took 4 days to look it all over, after which he came back and basically said, "Hey, why the hell would you have all this if it wasn't your plan the whole time?" The case was very downhill from there. Edit. Okay, some more clarification. She had done the same thing to her ex-husband, giving precedent. He and her children said so in their testimonies. One of her children even inadvertently admitted she'd told them what to say and paid them for it. We were able to name the date the relationship between her and my dad ended, which was months before she claimed, and outside the time limit to make it a de facto/common law marriage. We had testimony from the doctor at his ICU who said she tried to keep everyone, including his ex-wife, our mother, and us, his children, away from him. Meanwhile, she had his phone and computer and was trying to take over his contacts and business. We had proof of this. Her lawyer was a moron who constantly contradicted himself and the evidence. He lost documents, gave incorrect dates, and asked irrelevant questions of the defense. In the end, it was that her expenses for the relationship were deemed normal for anyone in any kind of romantic relationship, that gifts and meals aren't claimable for compensation, that her contributions to the household and business were not sufficient to warrant compensation, she never actually put any money into either, and that the relationship was not sufficient in duration to qualify as common law marriage. This case took 4 freaking years to settle, including 2 elevations of appeals. She finally gave up because she'd run into about $250,000 of court fee debt, as well as being forced to pay us $40,000. I don't get how people can actually plan this stuff from the beginning. Like, how do you do that and your brain doesn't immediately tell you you're a terrible person? Not only are you just screwing with someone's feelings, you are also essentially robbing them at the end? Like, what is wrong with you? What a weird way to try to get money, or just weird anything. I don't know, screw you. Not you listening, I mean the woman in the story. Anyway, next story. I had a misdemeanor possession case that I was defending. Client was driving his mom's car. He gets pulled over for playing the stereo too loud. There are pills in the center console, in a prescription pill bottle. The bottle has his mom's name on it. Client gets arrested and charged with possession of a controlled substance without a prescription. Case is obviously bullcrap, but the dumbest DA I've ever met in my life won't dismiss. We go to trial. During closing arguments, the DA says, "This case is a circumstantial evidence case." During my closing, I slap the jury instruction on the projector that says if a case is based on circumstantial evidence, and there's one factual scenario that points to guilt and one that points to innocence, the jury must find in favor of the defendant and acquit. My client was acquitted. Next story. Not a lawyer, but was taken to court once. A guy had taken my family to court basically because he had been dating my mother and things ended. So he then takes us to small claims court with an itemized list of everything he'd ever bought the entire family. Every cheeseburger, every Kit Kat. He even billed for things he did, like house repairs. Some of the repairs were terrible and ruined other things, by the way. He tried to unclog the sink and ended up destroying the main drain pipe for the house. Now, he had bought some more expensive things as well. No one asked him to, but he was one of the types that loved to show how much money he had, and would always talk about his connections, and would name drop someone anytime we went anywhere. So when he takes us to court with his full itemized list, the judge asks him to go first and present his testimony. He basically says, "While I was with them, I bought all this stuff. I took them to dinner all the time and all this, but it was the idea it would be paid back by them." Judge: "You bought a child a birthday cake with the idea it would be paid back? Did you ever say that these things were loans and not gifts?" "Well, no, but I shouldn't need to. That's the way normal people think." "Well, that's not the way I'd think. Case dismissed." Next story. Not a lawyer, but took my brother-in-law's landlord to small claims court. He's on SSI and I'm his conservator. We sued her for over $4,000 after she just decided she didn't like him and changed the locks on his apartment door. She also stuffed all of his belongings into trash bags and dragged them out to the curb. This was all done the day after she cashed his rent check. It all started because she was letting herself into his apartment with no notice and was going through his stuff while he was gone. When I found out about this, I told him to let her know that was not okay, and he did. That's why she kicked him out. I'm very organized and presented the judge with a folder containing photos, receipts, short videos on DVD, and the sheriff call logs, as well as a concise timeline of events. The landlord showed up with her son and countersued for the exact same amount we were suing them for, claiming the apartment was trashed, there were holes in the walls, and they would have to repair everything before being able to rent again. During the hearing, the judge asked for evidence of the damage to the room. The son whipped out his cell phone and showed a video panning and walking around the room. The video showed my brother-in-law's apartment obviously still being lived in, his stuff was all still there, and no visible damage, but there were a lot of posters and things hung on the walls. When the judge looked at the video, he asked, "Where is the damage?" The son replied, "You can't see it, it's behind all those posters." The judge frowned and looked at the video again, and then said, "Did you take this video when he was still living there at this time?" The son replied, "Yes." This was the clincher. The judge then asked, "Did you ask his permission to enter the apartment to take this video?" Silence. We were awarded the full amount. Next story. I had to go to court over a financial up when I was a student. Took advice from the university legal support team who said I didn't need a solicitor, so I went in alone. The judge didn't like this and postponed it for another date so I could prove I'd had more counsel first. The other party's solicitor caught me outside the court and said, "I didn't tell you this, but," and pointed out a huge error in the financial paperwork that made it very obviously come out in my favor. Went back to legal support, got confirmation it was right, went to the second hearing alone and got the entire thing thrown out. The other solicitor winked at me as he left. Saved me about £9,000. Nice chap. What an absolute homie move. Are you kidding me? This dude did not care he was going to lose that case. He just didn't want to see your life ruined over it. Hell yeah, man. Next story. Not a lawyer, but a relative of a retired prosecutor. Relative was working a misdemeanor criminal court. Cases get called in alphabetical order, and two women named Catherine Smith and Catherine with a K, Smith, were scheduled to have their hearings before the judge. Both had similar crimes, but slightly different. So the bailiff announces the next case to the courtroom. Catherine Smith, for one count of possession of snow with the intention to sell, and one of escorting. So Catherine Smith, with a K, stands up and indignantly cries, Whoa, just wait a second. Where the hell did the escort charge come from? I may deal drugs, but I am not a harlot. Easiest drug dealing case my relative ever prosecuted. Next story. Actual lawyer here. From the Fool for a Client file. Was interning at Legal Services after L1 doing discovery work for family law. My supervisor invited us to observe a hearing for our client to get a restraining order against her husband. At the hearing, the client discussed various times he threatened her. The man, representing himself, interrupted and said, "Judge, I never said any of those things. If I had, she wouldn't be standing here. Restraining order? Granted." Next story. Not a lawyer, but here's a story from the burbs. My buddy's in the middle of a situation like that right now. His psycho neighbor built a wall too high and doesn't have proper drainage on his property for the very small creek/natural drainage in between their yards. My buddy hired an attorney as the psycho decided to sue him over it. My buddy's engineer that looked over the property noted that not only did my buddy set his yard up right, but the neighbor created drainage problems. Neighbor hired his own engineer that proved my buddy was correct. Now the guy's likely to go postal. Case was going to go to mediation. Since both engineers found fault with the psycho neighbor, my buddy decided he's going to take it to trial. Turn the tables a bit. Next story. My favorite is a story from Jerry Spence. For those who don't know, he's a famous trial attorney. A witness on the stand was claiming that he had suffered injuries to his arm because of a city bus accident. Jerry asked him to demonstrate to the jury how far he can lift up his arm after the accident. The witness makes a feeble effort of lifting his arm. Then Jerry asks the witness to demonstrate to the jury how far he could lift his arm before the accident, and he lifts it much higher. The jury laughs, and the case is over. Next story. I am not a lawyer, but witnessed a pathologist win a case in court by destroying the defense's credibility. The question was over whether or not carbon monoxide poisoning could have caused certain signs of death in an individual, but the defense didn't study their chemistry very well, kept asking the pathologist whether carbon dioxide could have caused these signs. After thoroughly frustrating the defense by answering his questions incorrectly, the pathologist said very loudly, "Oh, I'm sorry. Did you mean carbon monoxide? Because that's a completely different thing." Completely destroyed the defense's credibility in front of the jury. They were done after that. So I guess the opposing counsel screwed himself by not picking up a book. Edit. For clarification, this isn't the only reason the lawyer didn't win. There were a lot of other things that didn't work out in his favor, but those were technical things that he probably knew about ahead of time. This was a case where he was asking a question that he thought was going to work out in his favor, but it worked against him. All because he made a basic chemistry mistake that he honestly should have caught. Yeah, I know. He's not a scientist, but you don't have to be a scientist to remember the difference between those two things. Getting terminology correct is part of his job. It's not like anyone caught a felony charge solely because he said that one thing wrong. Next story. I worked as an intern for a lawyer. Construction law in France is quite strict in regard to the neighboring of historical monuments. The city was denying a permit for heavy modification of the houses of our clients. They were arguing that because you could see the house from the church's bell tower, modifications were impossible. As a support, they kindly linked us to a 360-degree picture from said bell tower. We, as kindly, pointed to them that our client's house was indeed not visible from the top of the church. Building permit was greenlit the following day. Next story. Actual lawyer here, and this one was especially sweet. Was involved in an ownership/control dispute of a Venezuelan company. While we had no doubt who controlled the company, opposing counsel had created enough smoke to create just enough doubt for our federal judge to order us to file a declaratory action. After a few months, we received the equivalent of a declaratory order from the high courts in Venezuela, basically saying our client was in control of the company. We had the order translated and certified and drafted a motion explaining to the court how these orders from Venezuela work and how they are in effect the highest law of the land, which meant the case should be over. Our client was in control. Opposing counsel drafted an almost identical motion, but they had not received a copy of the newest order. In other words, opposing counsel agreed with our position that these orders from Venezuela would definitively prove who controlled the company, but attached the older order. We prevailed in the declaratory action, and the judge referenced the fact both sides had the same argument in the final order. Some background. The original Venezuelan High Court, First Order, created the equivalent of a receivership in the company we were representing. The receivership hired us to pursue an unrelated claim here in the States against an American company. The receivership was put in place by the shareholders and the Venezuelan government, as the owner of the Venezuelan company was embezzling money and running the company into the ground. There was another firm representing the company before we were hired, and they decided to ignore the first order and claim to the federal court here in Miami that they were the only ones representing the company and that we were the imposters. They argued that the first order was not valid, and the D-bag was still in control of the company. There was a second order that was the result of an appeal in Venezuela that was very ambiguous in its language and cast some doubt as to the control of the company. D-bag and his attorney submitted the first and second order as support to their motion. A third order was issued by a different Venezuelan appeals court which put the issue to rest. We asked for and received a copy of it. They didn't, either because they knew it was not supportive of their position or because they dropped the ball. We believe it to be the latter. Our motions cited similar case law and advanced the same positions, but we were interpreting different orders. Next story. A guy I used to work with was going through a messy divorce about 20 years ago now. His soon-to-be ex-wife was a psycho and her father was a psychologist, so he was pulling all of the strings. Even had my coworker arrested at work one day, BS charges. The divorce case took years, one young son involved, and at every turn my friend lost because of something the father filed or another string he pulled. In the end, they were in court, and it was very apparent that my friend was going to lose custody and all visitation rights. Every plea he entered was squashed, and he was mentally broken. The judge asked the ex-wife if she had anything else to add, and she said that she had a written statement that she wanted the judge to read. The bailiff took the paper from her and handed it to the judge, who unfolded the note and read it. He stopped for a minute and asked her if she was certain she wanted this note added to the case. She said yes. The judge turned to my friend and said, paraphrasing, "Mr. Blank, all these years and all these claims that I ruled against you, the court profusely apologizes. I did not believe you, but I do now. Ruling in your favor," bangs the gavel, "I grant you full legal and physical custody of your minor child. Bailiff, please handcuff Miss Blank." My buddy was stunned that he won and happy at the same time. He later found out that the note read, "Give me my son or I'll freaking end you." Ah, yes, why not? You're winning. Why not threaten the judge? A bold strategy. I don't think it worked out for her, though. Next story. Obligatory, I am not a lawyer, but I am a certified paralegal. I went to court and spoke for a friend at a hearing. I can ask questions to both parties and address the judge. The only thing I can't do is object to the other lawyer's line of questioning. So here's what happened. Best, a male friend, was fighting a restraining order against him by his crazy ex-GF. Everyone was in the courtroom that day, including her. Her lawyer questioned my boyfriend about their relationship. As an aside, they lived together. He moved out and got his own place, but they were still together. She just got obsessively crazier to the point where they broke up. She wanted some stuff back that she gifted him, and he refused to let her in while not home to get it. She got crazy angry, made a scene in his front yard, getting cops called, and the neighbor's dog taken. It was for being a pit bull in a park where they weren't allowed. Bullcrap, I know. Next thing you know, she's got a restraining order on his mom, who lived right next door to her son, and is trying to get one on him and sue him for his crap back. So when he's on the stand, I'm questioning him about the incident about her showing up and trying to break in. His mother called him the moment she saw her banging on the door, so he beat the police there. She had gotten in and was in the living room. I asked him if he was in fear of her, and he says absolutely, because upon walking in, she slid an iron bar from her sweatshirt sleeve, telling him to back off. He was just standing there, mouth wide and shocked. Cue her turn on the stand. I asked her about the day, if she had gotten in. She insisted she did via a key, which we knew was a lie. She never had a key. So then I asked her about the iron bar. Why did you have it? Where did it come from? My cop friend gave it to me to protect myself while driving from road rage. It's in my car all the time, so I just brought it with me in case anyone was inside that wanted to mess with me. And did you have it up your sleeve? Yeah, 'cause I didn't want neighbors to think I was breaking stuff. She was bawling and slamming her fist in her thighs and pulling her own hair, wailing. I rested after that. She admitted to trespassing while carrying a concealed weapon. Both restraining orders rescinded. She was asked to stay after court was adjourned, and the judge handed her mandatory therapy and committed her for observation. Screw you, Shauna. Next story. Not a lawyer, I know, but my parents were in a lawsuit where this happened. They owned a business, and on either side of the business were businesses as well. Their neighbor to the left sued us, claiming that we'd been using their property without paying them or without permission, that we were essentially trying to adverse possess it. We got a surveyor to come in, and the surveyor said that not only were we using all of our property, but we had been paying rent to them on about 20 feet that was also our property. Obviously, they weren't happy, so they got their own surveyor, who gave us 50 feet. We won the lawsuit. Now their little patch of property has a rusty fence all around it with "Keep Out" signs everywhere. It's about 20 by 10 feet. You know when you're arguing with someone, and you tell them to look it up, and then they do, and then you're right? I can imagine that this is the same thing, or feels the same, but even better, because you actually get something out of it at the end. And hey, the satisfaction is good enough for me most of the time. I can't imagine how good this would feel. Next story. When I first started, my firm had me on a case where the client claimed he lost because of ineffective assistance of counsel, basically saying the old lawyer didn't do his job. So we prepare an argument based on not asking the right questions, not communicating, etc. We think it's going to be a tough case, but not unwinnable. Then we get the response to our old complaint, where the old lawyer argues that he was only ineffective because he didn't have time to prepare for the case, and only reviewed it the morning of the trial. He had known about the case for months, by the way. The judge saw this, and during the trial we had essentially asked, isn't this the definition of ineffective counsel? Not giving enough time to your client? The silence from his side of the court was amazing. Needless to say, the trial didn't last much longer after that. Thanks, opposing counsel. I guess you were ineffective for both of you. Next story. Not a lawyer, but in a suit against an employee, her attorney presented our contract and their contract to demonstrate the differences to prove that his client hadn't stolen ours. So if you hadn't, then, where did you get our contract? Idiots. We won. Spent a couple $100,000. Defendants both ordered to pay $10K, filed bankruptcy, and dissolved a business. Started anew with another competitor. Next story. Am a lawyer, but this was from my time as a law clerk. Tattoo artist around 40 gets charged with assault of an employee. The victim is 17, very fragile, and barely able to sit in the same room as the defendant. She stares at the table the entire time and you're barely able to hear her speak. She doesn't elaborate much on details, but basically, he forced himself on her after closing the shop for the day. The defendant's story is that the employee came onto him and that it was consensual. The defense calls a witness, another employee at the shop, basically to tell everyone what a stand-up guy the defendant was. If I were to guess, I think the court was undecided, but maybe leaning on a not guilty verdict up until this point. The defense witness takes the stand, starts telling a story of how the defendant, while doing a tattoo on her, tried to hold her down and kiss her, but had to stop because someone else came into the shop. Game over. Perp got convicted of assault. A week later, he declared that he was satisfied with the penalty and chose not to appeal. Just to clarify, this happened in Sweden. Next story. Not a lawyer, but I am a former insurance fraud investigator. We were at a hearing before the WCB. I had something like 18 hours of video spread over a 2-week period of a claimant doing roof work. The problem for me was that the video didn't get a clear face shot. Normally, what we liked to do was get in close, show the face for a positive identification, and then zoom out. Bonus if the claimant was wearing distinctive clothing that could be easily tied to him. Because of where this guy lived, all I could do was show someone who matched his description getting out of a truck registered to him every morning. He wore a hat, he had a beard, and he had neither at the hearing. So the company lawyer is prepping me and basically letting me know to be on point, because the claimant's attorney is almost certainly going to challenge the fact that it is his client in the video. If the video got tossed, the case was done. About 2 minutes into the hearing, claimant's attorney agrees to stipulate to the fact that it is his client in all of the video. All of it. Our attorney was shocked. That was pretty much the only leg he had to stand on. Claimant attorney was incredibly smug right after this, like it was a no big deal. Evidently, his strategy was to show that his client wasn't really a professional roofer since he was doing the roof the wrong way. He tried to get me to answer questions about roofing. I refused as it was beyond the scope of my work, and he just wouldn't let it go. After about an hour of back and forth over this, the judge finally said, "Counselor, it doesn't matter if your client is doing the work well. What matters is that he has stated numerous times and under oath that he cannot work. Whether he's doing it for free, for cash, or for fun has no bearing on the fact that he's doing roofing work while collecting compensation benefits, which he was awarded because he couldn't do roofing work." The guy lost and had to repay a bunch of benefits. After a few of those hearings, I began formulating a list of lawyers I would never hire, and ones I would absolutely want on my side. Next story. I am a lawyer. Sued a trucking company for underpayment of wages. They claimed they paid by route and not by the hour, despite doing their payroll by the hour, because they had a USPS subcontract that supposedly told them to pay by the route. Defense calls the owner of the business to the stand and starts questioning her about the contract, which is clearly incomplete. She explains that the company gets a new subcontract every 4 years without fail. On cross, I flip to the first page of the contract and read the date, which is in the spring of 2011. Did I read that correctly? Yes. And you get a new contract every 4 years. Yes. So you got a new one around the same time in 2015? Yes. And why haven't you produced that contract today? I haven't seen it in years, but it's the same thing. Where does this contract tell you to pay your drivers by the route? When she can't answer, I follow up with, and the 2015 contract that we don't have says the same thing. My client started working for them at the end of 2015. Their whole argument was based on a contract they couldn't even find. We won. Next story. Ooh, I've got one. I was about 5 when this happened, but my parents explained it years later. There were a series of trees on the sidewalk in front of each house on the street. Although they weren't part of our yard, the tree was owned by my parents and they were responsible for it. Some guy tripped over a branch and was seriously injured, he said. He came after my parents for all of the money. The dude showed up with a mountain of evidence. Hospital bills, psychologist testimonials, a photo montage of his slow and painful recovery, etc. Apparently his lawyer brandished this stuff like a bat before court. My parents' lawyer thought he had a good case, until the first day of court when he walked over with a picture and asked, "Is this your tree?" My parents looked at the photo in disbelief and said, "No, that's actually not our tree." The opposing counsel repeated the question. It went back and forth a few times until my parents' lawyer incredulously produced a picture of their tree, which was, even to the untrained eye, completely different. At that point, the opposing counsel whirled around and started screaming at his client. "You said that was their tree!" Case summarily dismissed. My parents walked out in shock, came home, and bought me ice cream. All's well that ends well. Next story. Not my case, but I was in the courtroom watching a trial. Defendant who was accused of flashing a guard and pleasuring themselves until, As a pro se defendant, he defended himself at trial without an attorney. Prosecutor was doing well proving the case. When the female deputy was on the stand, the defendant asked her one question. "If you saw me do what you claim I did, then how big is my dong?" The deputy responded by raising her hands and estimated about 15 inches. The guy grinned, turned to the jury, nodded, and said, "Yeah, that's right," and sat down. Obviously, he was convicted. He was doing a 10-year prison sentence, so this conviction wasn't much of consequence, but I will never forget it. Next story. Accidentally proved? Not often. Made tactical errors? Often. Arguing a case on a voter recount in front of a judge. Judge says, "I'm going with X." That's in my favor, so I shut up. Opposing counsel, in arguing a different point later, suddenly goes back to the earlier point and belabors it. Client, also a lawyer, says to me, "Don't say anything." I whisper back, "Don't worry, wasn't planning to." Judge begins rubbing his nose and looking irritated. After a few minutes, cuts off opposing counsel, saying, "I already ruled on this point. Mr. Smith," me, "anything to add?" I replied in the negative and won my motion. Would it have come out differently? I don't know. Did opposing counsel make it easy for me? Yeah, absolutely. Next story. My opposing counsel made some off-the-cuff remarks about how their client had to go to another remote office to get all the records they wanted to use against my client. That let me know the witness they were trying to use to introduce the records as evidence wasn't actually familiar with the records or records-keeping process. In the jurisdiction we were in, records were exception to hearsay rule, but you needed someone familiar with the creation and maintenance of the records to get them admitted. I attacked the witness's qualifications to get the records admitted and ended up getting the records excluded. I then made a motion for a directed verdict on the grounds they couldn't prove the case without the records, and won, all because the opposing counsel complained that their witnesses had to go out of their way to get records for the court. Next story. Domestic violence case where the husband beat the wife senseless. Landlord tried to evict wife for breach of lease due to the beating. Landlord claimed wife violated lease terms by allowing police to be called to property and causing a disruption. My argument was that as a domestic violence victim, wife is covered under VAWA, and property is HUD subsidized. Also, Maryland law offers DV protections too. Landlord's counsel during his opening talked about how my client was beaten and the police were called and an ambulance, etc., and I just stood there looking at him. When he finished, judge asked if I had anything to say, and my response was, "No, Your Honor. I believe opposing counsel has said everything that needs to be said." Judge smiled and ruled in my client's favor. Landlord can't evict DV victim. So was the opposing lawyer trying to lose that case? Because if they were, then fair enough, honestly. That's a pretty bad case to have to take. You're doubling up on bad karma, man. Essentially defending a domestic violence perpetrator and a landlord? Come on. Next story. My public defender wife, not a Redditor or I'd get her to speak for herself, was trying a case where the defendant was accused of filing fraudulent prescriptions. Now keep in mind, PDs deal with a lot of shady characters who maintain their innocence with increasingly implausible stories as the evidence gets worse, so you can get a bit jaded after a while. But you don't have to believe your client's story to defend them vigorously. So the prosecution has grainy surveillance video of someone who looks like the defendant getting the prescription filled and the ID used to fill it, which belongs to the defendant. Defendant maintains that someone stole his ID and is using it because they look similar, but never reported the ID as stolen. Wife is skeptical that the jury will go for that, but she's always willing to go to trial if that's what the client wants, so preps the defense and heads into trial. Prosecutor brings in the pharmacist who reported the prescription issue, goes through the usual routine of establishing who she is, where she works, was this the ID used that day, etc. Finally, the prosecutor asks the pharmacist if the person who attempted to fill the prescription that day is in the courtroom. No. Oops. Next story. Parents were being sued by their landlord, and parents had a countersuit against him. Parents were moving across country and found this house to rent. They did a walkthrough. Looks great. Landlord wants first, last, security, and $1,500 because they had a dog and 2 cats. Fine. It was somewhere in the $8,000 to $9,000 range, no big deal for them. They're set to move in on a Monday, so my mom flies in on Saturday to do one final look over, sign the contract, and get the key. Perfect. They are now the tenants. Monday they arrive, and the house is freaking trashed. The landlord has moved a bunch of his stuff into the garage, shed, and one of the bedrooms. There's crap in the toilet, pee on the floor, garbage laying everywhere, and used rubbers. I can't really do this justice, but my mom took pictures and videos throughout the entire house. She calls the landlord and tells them they're not moving in with the house in this condition. He tells her to clean the house and he'll buy the first tank of oil for it. It was empty. He tells her to do it, or he's keeping all the money for breach of contract. A lot of back and forth happens and tons of harassing texts and phone calls from him. Court day comes and everyone's ready to submit their evidence in front of the judge. Parents have photos, texts, the contract, videos. Landlord only has the contract, but his contract is different than my parents'. He's included a section that states that they permit him access to the house for his storage needs, and that tenant is responsible for all on-site cleanup and maintenance after accepting the key. The best part was that the date of the signatures on his contract was the date they moved in, not the date my mom flew in and signed. Judge tells the landlord he's a special level of stupid, and then the judge's final remarks were about how disrespectful the landlord was to show up in shorts, a Hawaiian shirt, and flip-flops in his courtroom. He never paid a dime, then claimed bankruptcy, then started a business under a different name. 2 years later, I went to his house, let out all but 19 psi from his tires, and superglued the caps on the valve stems. Crappy landlord taking L's? Hell yeah. These are the stories I want. The judge is right though, that guy is a special kind of stupid. If you're gonna forge documents, do a better job, man. But also, just don't. Next story. My ex-girlfriend's father had a case where he brought in a decoy defendant. He then asked a key witness for the prosecution to identify the suspect in the middle of court. The witness turned and pointed to the decoy defendant, who was just a buddy of my ex-girlfriend's father and had nothing to do with the case. The witness was caught lying with his pants down, and the whole thing was hilariously embarrassing for the prosecution. Turns out, even if you're right, it's a huge no-no to trick witnesses like this, though. My ex-girlfriend's father had to go through an ethics investigation and was suspended from trying cases for a while. Edit. To those asking why it was a no-no, I've got no clue. But apparently he violated a couple of court procedures and broke a state law. An actual lawyer might be able to comment more on it. I assume there's some law that the real defendant has to actually be at his own court date and you can't have a proxy, maybe. Anyway, next story. When I first started practicing, I handled a custody case where my client, mom, had a problem with the dad smoking around the kids. I asked him if he regularly smoked around the kids, to which he replied he doesn't smoke tobacco, only weed in the house. Obviously, this raised eyebrows. It was illegal in my state. He then went into a long diatribe about how he only follows the law of the streets. Yeah, he actually said this, and he doesn't recognize the authority of the court he was currently in front of. Needless to say, mom got full custody, especially after dad was arrested for going to the court services officer's house late at night and trying to kick her door in. Next story. Not a lawyer, but I work with lots. We deal with car accidents, and this particular girl was claiming severe whiplash and lower back injuries from a minor rear end. Some of her injuries were legitimate, but she was claiming her life was ruined and she was unable to function in society. She worked as a physical therapy aide studying to become a PT, so she knew what to say. But she didn't know what not to post on Facebook. She claimed she was in constant pain after the accident and couldn't go to the gym. The day after the accident, there's a pic of her lifting weights. #accident can't hold me back. She claimed a month of lost wages, but there she is in a patient graduation from treatment photo on her work's website the week after the accident. She missed 0 days of work. She claimed she couldn't travel anymore, and guess who had photos of Vegas strippers all over her Instagram for her sister's 21st? She asked for $200,000 and she got $9K for the legitimate injuries and mediation, as the mediator laughed at her Facebook feed. Next story. Plaintiff was claiming insurance money because he accidentally chopped off his fingers while cutting bamboo with a machete, and the insurance company, our client, refused to pay the insured amount. During the hearing, the plaintiff attorney began to demonstrate with a rolled-up sheet of paper how his client was cutting the bamboo when the accident happened. No matter how he tried, he could not reproduce the position of the fingers with the alleged cut of the machete. The only possible match would be if the plaintiff had deliberately extended his fingers over a plane surface and hacked his own fingers. Based on this disastrous performance, the judge determined an expert opinion and later dismissed the case due to deliberate self-mutilation. Next story. My family did foster care for a few years and we fell in love with the last girl we took in, now my younger sister. She was required to keep in regular touch with her emotionally and physically abusive birth mom, the intention being for them to eventually reunite. This woman was a horror. Every single time they interacted, she'd spend the duration painstakingly shredding my sister's self-confidence. My parents worked hard to establish a strong rapport and a supportive environment, and she blossomed under their care. She's one of the most resilient people I know. When the state tried to return her to her mom, she didn't want to go, so my parents sued, I think. I don't really know all the legal details, but they were going for guardianship. This seemed like it would be an uphill battle. Here we were, a family of randos trying to steal a kid from her rightful mom. We were really afraid she would have to go back and that her crappy family would systematically undo all the hard work she'd done rebuilding her self-esteem. Fortunately, her idiot mom decided to represent herself at the guardianship hearing. I wasn't in the room, but I heard the audio recording later on, and it's incredible how thoroughly this woman shot herself in the foot. Some highlights. She kept trying to testify while cross-examining people. For example,
"Would it surprise you to learn that blah 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 blah?"
The judge called her out for this like 6 separate times, and she just kept doing it. She would admit to various incidents of emotional abuse, but then try to argue it was all justified because her daughter was being a jerk. She'd ask witnesses, for example, "And wouldn't you be angry if your daughter did XYZ? Yes or no?" My personal favorite, and the best example of her proving our case, "It is absolutely not true that I hit my daughter with a wooden spoon. I only tried and missed. Look, I'll prove it. I can show you the mark it left in the door frame." Needless to say, we won guardianship. My sister never has to see that awful woman again. Next story. I'm not a lawyer, but a couple of years ago, my family was sued by our neighbors for having a fountain in our front yard because it supposedly, quote, made too much noise, causing our neighbors to, quote, lose sleep. So my dad, being a nice guy, said, "Okay, I'll try to fix it." We put up walls around the filtration unit and redid the pipes to dampen as much of the water/splashing sounds as we could. After finishing all of this, my dad even got a noise technician, I don't know what they're called, to come around the house with a decibel reader to verify the noise was virtually gone. The tech walked around a couple of times and told us the highest reading was 28 dB, so we're good to go. A couple of weeks go by, no problem, but then we get served a lawsuit again. Same issue. So my dad is starting to get aggravated over this, and this time decides to get our own lawyer to dispute this. Well, court day comes and my dad and his lawyer have all the sound readouts, pictures of the stuff we did, etc. The neighbors brought their evidence as well. Their strongest piece of evidence was recording from inside their house that supposedly showed how loud the filtration unit was, but you couldn't really hear anything except for our neighbor lady going,
"Do you hear it? Oh, right there. Oh, it's so loud."
So when that evidence didn't bear the fruit that they wanted, they decided to show their next piece, which ended their case. The next piece of evidence they tried to submit were pictures of our filtration unit, walls, and the various other things we did to dampen the sound. Well, in order to take those pictures, they would have needed to be on our property, inside the walls we built. So our lawyer sees this and begins to ask how they got those pictures. They admitted to the court they trespassed to take them, and thus begins their downfall. Our lawyer showed the judge the decibel report and all that good stuff, leading to our neighbors admitting that the noise never actually bothered them, but it was the sight of our ugly filtration unit. The case was thrown out, and our lawyer then told us if we wanted to countersue, we can, so we did. We got them on trespassing and harassment that they provided the evidence for. As it turns out, they were also upset at the fact that the HOA made everyone move boats and trash cans to the backyard, so our neighbors were upset we got to keep the filtration unit in the front. Like, really? Next story. Best I ever saw was a psycho neighbor. Their name was Fig Jam, which stands for F I'm good, just ask me. They used to move to a new place, pick fights with the neighbors on all sides, move, rinse and repeat. Massive piece of crap in general. Well, one day their neighbor, Jim, over their back fence got a bizarre legal document stating their intent to sue over a tree in their yard whose roots had supposedly moved 20 meters down the hill to restrict and break their pool pump and piping for said pump. So, Jim, in his defense, pulls in a plumber, who happened to be a mate, to dig up the trench and extract said roots for DNA testing in a lab. When they did this, they spared no expense. We're talking 15 people on site, we're talking bobcats, the freaking works to make it the most expensive trench they could. Funnily enough, the DNA tests proved it was from Fig Jam's own tree, which was a lot closer to their pull pump. Who would have thought it? They were liable for the cost of Jim's legal defense. The plumber and the lab hit Fig Jam with a $30,000 bill. Couldn't have happened to a nicer person. Fig Jam is an incredible acronym. How did you even come up with that? In the original post, it's not all capitalized or anything, so I didn't know it stood for something until I sort of read it out and was like, what? Oh. Anyway, I don't get how you go through life like this. Wouldn't it just be exhausting picking fights everywhere you went and then having to pick up and move all the time? You do you, Fig Jam. Keep those plumbers in business. Next story. Not a lawyer, but I had a legal dispute settled this way. Had a car crash in which both myself and the other party were driving towards each other, but too quickly around a corner. We crashed. A few minutes after the crash, another driver, who knew the other driver in the crash, arrived on the scene and offered to act as a witness, despite not having seen it. In this witness's description of the event, they started off by describing the roads as totally blocked by hedges, no visibility of the traffic ahead. They then went on to describe how they could see me driving way too fast for the conditions, apparently having seen me from miles ahead. Obviously called them on the contradiction and got the blame split 50-50. Next story. I was on jury duty once and a couple of guys had robbed a place. So the guy who was robbed was up on the stand and their lawyer was doing the usual questions to clear everything up at the start, and when asked if he took an inventory before and after to show the value of what was missing, the guy just said, no. Whole case thrown out the window in about half an hour. Next story. I only do civil litigation. You would think it would generally be a battle against equals, professionals v. professionals. It's not. I face a fair amount of parties representing themselves pro se, often otherwise smart people who wouldn't think to do their own plumbing or operate their own appendix, but have no qualms about appearing in court on their behalf. Surprisingly, they don't know what they're doing. One of my favorites from a deposition was, we didn't pay Company X's invoices because we heard they were going through a bankruptcy. A, they weren't, and B, it wouldn't be a valid defense to non-payment if they had been. Next story. Not a lawyer, naturally, but a friend sat on jury duty recently where this happened. The defendant was being prosecuted for attempted murder, shot a guy, and he claimed it was self-defense. Prosecution started and made their case, brought witnesses, etc. After 2 days in court, when prosecution rested their case, the judge said that even in their version of the story, it was so obviously self-defense that the defense didn't even need to speak. He threw out the charge and the jurors got to go home. Next story. I'm not a lawyer, but as an arborist, I get asked about trees and the law all the time. So I know a lot about tree law and stay informed on it. Occasionally, I get called to a property to write a letter indicating that my prospective customer's neighbor's tree is dangerous or needs to be pruned or whatever. At least half of the time, it's not true, and the person is amazed that I won't just write the letter anyway. Sometimes if they're a real jerk about it, I'll visit the neighbor after. If anyone is curious, in the US of A, you have the right to prune or remove, and the responsibility to maintain all plant matter on or over your property. This means that you can cut back branches growing from trees from other properties without permission, and that if you neglect to do this and damage results, it's on you. Next story. Not a lawyer, and I guess not them proving their case, but shooting themselves in the foot. I took Apple to small claims court over refusing to fix my MacBook. The story leader from the Apple store in question appears for the defense, to which the judge says, no, you can't do that. You either need to be attorney hired by Apple or Tim Cook himself. The guy says he understands, but just wants to try and rectify the matter by getting the laptop fixed. Judge grants a continuance for us to come back 2 weeks later after Apple's had a chance to fix the laptop. Sure enough, they got it fixed and comped the whole repair. We show up 2 weeks later for the follow-on hearing, and it's a different judge, who's booking through the docket like his lunch is getting cold. We come up, and the judge's first question to the Apple employee is, "Are you a lawyer?" No, but this is just a continuation, and I believe we resolved the matter." Judge asks, "Why didn't we just file for dismissal if the laptop was fixed?" I said, well, Your Honor, I appreciate Apple fixing the laptop, but I gave them ample opportunity to do so without suing them. Now I'm out $60 in court costs because apparently that's what it took to motivate them. I'd like them to cover my costs. I was suing for replacement value of the laptop, so this was a huge bargain for Apple, but this idiot contests it, says they shouldn't have to pay the court costs because they weren't obligated to fix the computer. Judgment in favor of the plaintiff for $30. I'm a huge stickler for principle, and I wasn't happy with this. And the state code actually explicitly said that as the prevailing party, I was entitled to all my court costs. So I emailed the paralegal at Apple, who had previously emailed me just advising that they were contesting it and would have the store leader appear, CC'd the guy and told them both, look, you owe me $60. Here's the section code. We can save ourselves all a lot of time and you can just remit me $60 and we'll be done. Or if you only want to send the $30, I will appeal the decision to circuit court and those costs will be $130. They had, as Apple does, been snobby through the entire time, thinking they're above the law. Note, twice they've been told they need a lawyer and neither time sent one. They said, nope, you're only getting $30. So I appealed to circuit court. I now was spending $130 to recover an additional $30. Circuit court is big boy court, so I'm thinking they have to be hiring an attorney now, which means either they're stupid enough to waste hundreds on this, or they should settle to avoid that. Show up on our hearing date, there's the same freaking store leader again. Our case is called. Judge's first question is, are you a lawyer? Apple apparently anticipated this, and this guy had a letter from Apple's general counsel saying, yeah, we'll allow this guy to argue on our behalf. The judge says, that's fantastic, Apple's allowing it, but the court will not. Guy from Apple then goes, oh, well then can we request a continuance so we can determine our next steps? Judge asks me if I object to the continuance. I say, yes, Your Honor, I absolutely do. Apple has been told twice before this by the small claims judges to get a lawyer, and both times flagrantly ignored the court's request and seems to think they don't need to listen. Continuance denied. Apple Bro was ordered to sit down and shut up. I basically go through my recap of the case and why the code says I'm due to the full costs, and now also the costs for the appeal. Apple guy tries to pipe up at some point to contest something I said, and judge had to, meaner now, tell him to shut up or he would be held in contempt. He was now nothing more than a spectator to the proceedings. Judgment in my favor for everything I asked for. Now in my state, after 10 days, I can file for garnishment. I emailed Apple requesting that they FedEx me the amount within those 10 days. At the time, being out this $200 was actually stinging. They clearly learned nothing about being cocky and said, nope, our accounts payable process can take up to 60 days. On day 11, I filed for garnishment against Wells Fargo, their payroll bank. Court approved it and ordered the bank to pay out the judgment amount plus the $40 for the garnishment fee. OP, I understand being a person of principle, but God, this sounds like a lot of work, man. I don't know if this was worth it. If the goal was to teach Apple a lesson, I guarantee you they do not remember you. Still, you got all your money, so good for you. Next story. Oh boy, here we go. Obligatory, I am not a lawyer. I'm a medic, and sometimes our medical reports get used in courts. Sometimes we have to testify with it, and others we don't. This is going to sound morbid, but my favorite are the child abuse cases because I can write everything the kids tell me in the back of the ambulance / put it in my report, and I don't have to tell the guardian anything, unless one of those statements includes I want to hurt and or end my own life or others. Then I can disclose the fact that my patient is wanting to take their own life to the nurses and staff at the hospital. That's different. My partners usually ask me to do the petty abuse calls even if they're really simple, simply because I'm young. I'm also a small female that kids see as a big sister or protective type, and they like opening up to me because my assessment is more like hanging out with your older sib than a medical questionnaire. Let me give you a few personal examples where the opposing counsel, parents, have admitted they're performing of child abuse. On the transfer side, I work critical care and 911 mix-up. I have the ability to run both. I'm bringing child X from this facility to Super Special Children's Hospital for treatment for a spiral fracture on their left leg. Child X is about 4 or 5 years old, and the nurses tell me it's a potential child abuse case. Spiral fractures are usually a sign of child abuse because of how they get them. Parents are still being allowed to ride with the kid, even though I really don't want them to. I concede and let what I thought was the father of the child ride with us. Was on the kid's paperwork, kid was on his insurance, etc. The guy creeped me out, but I was in the butt crack of the city and it was late. Load the kid up in the ambo. They're really sleepy from pain meds, so I quietly dim the lights and leave my work light on by the captain's chair behind the stretcher where my monitor is resting with kid's vitals. HR, heart rhythm, BP. The kid stirs and sees creep dude and pretends to go back to sleep, but I can see the HR monitor keep going at a slightly tachycardic pace, clearly not sleeping. So I begin to ask questions for my medical record, and I don't tell him what he initially told the nurse what happened. I pretended I didn't know. They also didn't know they were under investigation at this point. I had to be on the DL. I also asked him if he could sign for the patient, since the patient was a minor.
I'll let the mom do that. I'm just her boyfriend.
You're not the biological father?
Nah, I've been with the mom for about 2 years now.
Okay. He says that child X was falling / rolling off the couch and he caught their leg to keep them from rolling off. A 4 or 5-year-old would have been just fine rolling off the couch, theoretically.
I let go when I heard a pop.
Did you grab them by the ankle or thigh?
Calf or ankle, I don't know, they slipped.
At this point, Child X begins to whine. I can't blame them, we're going down some pretty crappy roads. I ask Creep Dude to scoot over so I can make sure the immobilizer is still in place. I use the pen light to see, and I keep the kid covered in blankets. I see a huge, blotchy handprint on the calf starting to form, but also on the thigh, like someone was twisting it. I readjust it, cover the kid back up, and ask if him and me can switch places. I put the monitor at the kid's feet so I can still see it, and the kid relaxes and almost immediately falls back asleep. So wait, I'm sorry, I was distracted by Child X's vitals. Can you tell me what happened again? I was smiling sweetly. Oh, yeah, sure, I grabbed them by the thigh and kept them from rolling off the couch after I told them not to. Were they doing it a lot or roughhousing? They were annoying me, but I didn't want them to get hurt. So you grabbed them by the calf? Yeah, the calf. I put that entire conversation in my report, and when we got to the children's hospital, I told the charge nurse what happened and privately showed her the now obvious handprints. Technically, Creep Dude wasn't wrong. He did grab the kid by both the thigh and the calf, but he contradicted himself in conversation because the story wasn't true, and I think that he might have thought he was in the clear since the bruises hadn't quite formed yet, or he didn't see them. The kicker, the kid came to before I started to leave and thought I was a big sister. He said, Ash, not my name, make sure Dan doesn't hurt you too. Creep Dude went to get Mom and other siblings, but I got to watch the crap show of him being violently arrested. Without that convo in the ambulance, they might not have had evidence. I know it was only my word versus his, but my documentation is a legal document, and I couldn't put mechanism of injury, asked Guardian. Guardian was vague or inconclusive. Read the following statements from Guardian. So Dude got quite a bit of fallout from it. He got walked past my ambulance on the way out when we were cleaning up, and he was spitting and cursing at me, calling me every name in the book, saying he was going to come find and assault me. Fun times. Another, shorter story was when I got called out to another DV case where the mom just blatantly admits she gave her baby H to, quote, help her sleep. That was a pretty open and shut case. Baby almost slept forever. She didn't tell the cops what she told me, but my documentation, along with hospital records, got the kid taken away and her put in prison. My favorite, morbid, but I got to help a child, so it makes me feel better about what I heard, was when Granny and Mom were trying to get their story straight and I was behind the door without them knowing. I was just waiting on the nurse for patient report before I got in there. Granny.
Now we say that he spilled hot water for coffee in his lap, right? When that ambulance driver gets in here?
Mom.
Yeah, they don't need to know about JD. He got enough charges already. Why JD giving him a bath anyway?
I don't know. I was with Keisha getting my nails done and weave. We were gonna go out to the club later and JD said he was watching him for me.
JD told me he wouldn't stop whining and crying and he was gonna give him a bath.
I pulled the charge nurse in with me and made the shh motion. She was now listening too.
Why was he crying in the first place? Maybe he was hungry or something? I ain't been home in a few days. I don't know what JD's been feeding him. I gave him a bottle while we waited for the ambulance and he sucked it right down.
Mama, why is there blood in his diaper?
I don't know nothing about that.
We hear diaper being undone carefully. At this point, me and the nurse heard enough. Put all of that in my report. She called the cops and CPS. You know what they told me when I walked in? He reached up and spilled hot water I was making coffee with on his legs. No, lady. Whoever JD was burned and sodomized an 8-month-old. Your 8-month-old. It sucked to pretend to be nice to them. I wound up holding and half carrying the baby the whole ride. So many blisters popped, and I don't even want to think of the internal damage. I didn't let them ride with me. I love helping to put abusers away, especially when most of my patients are so very helpless. My medical documentation and the fact that patients, and their parents in this case, lie, helps me and the courts put the abusers, opposing counsel, away. When I catch them in the lie and it doesn't match the physical evidence and or what I saw on scene, it gets used in court. People will lie all the time. This also happens with police reports. To be honest, I don't give a damn what your charges are. Just tell me what you took because medications can end you. Sorry, this became long as hell. I just get carried away sometimes. I hope it's relevant enough. People really suck. This was a big one and I was considering cutting it out because it's not super relevant, but I feel like the work that OP does is too important not to highlight, and it is the same general vibe. Typically, people who have done something wrong proving that they've done something wrong without knowing it, and just looking like absolute idiots. And if there's ever time I can show child abusers to be absolute pieces of garbage and dumb human beings, I will. So that's why I left it in. I hope that's alright. Next story. Not an attorney, but I did an internship at the city's attorney's office one summer, leading to not wanting to be an attorney. Man was suing the city for evicting him from a public housing development. Claims he doesn't speak English and forced the city to hire an interpreter for the hearing. City says he was evicted because he was raising chickens in the apartment. His attorney insists that's absurd. No one would do that. Pushes for proof the chickens were his clients. Judge wasn't convinced about the proof. Everything looks like it's going well for the guy until it comes up that the chickens were given to a farm for slaughter. Guy jumps up and starts yelling, "Give me my chickens back!" in English. Judge starts laughing. Attorneys start laughing. Case is dismissed. Next story. My wife is a court clerk. She told me a story a court clerk friend of hers told her. DA has a shaky case at best against the defendant. Police were trying to pin a drug charge on a guy with literally zero evidence. The report read that a certain amount of weed and ice were found and recovered in the defendant's car, but the evidence was, quote, lost. Guy maintains his innocence and has no priors. The defense attorney is destroying the officers on the stand for inconsistencies between their accounts and poor documentation on the official police report. The prosecution's ace in the hole was a part of the police report that read something to the effect that the police canine said there was marijuana and ice in the car. Rather than saying something like the police canine alerted the officers to the presence of drugs, it left the defense attorney no choice but to call the police canine to the stand to confirm its testimony. DA drops the case. Next story. I'm not sure that opposing counsel has ever managed to prove a case completely, but there are constantly errors that make my job a lot easier, particularly as I become more senior and more often have opposing counsel that is less experienced and able. Important to keep in mind that I was once the junior party, and probably made many errors I didn't even know I was making. I honestly look back at some of the early mistakes I'm aware of and feel mortified. I expect this is common for most professional people. I'm just glad I'm not a doctor and didn't accidentally end someone. Yeah, as Opie said, not as bad as doctor, but I feel like being a lawyer, you would definitely stay up at night sometimes just being like, oh man, I really screwed that one up, didn't I? Oh no. But for the most part, it's important work you guys are doing, so thank you. It's definitely something that experience helps a lot with, which unfortunately means you gotta make some mistakes. Anyway, that's the last story for today. I would like to thank you all so much for watching. I hope you all have a wonderful day or night wherever you are, and I will see you in the next one.